In this video, we're going to look at what you should do if you want to reject a car under the Consumer Rights Act 2015 or under the Sale of Goods Act 1979. We're going to look at three key aspects: who to sue, why are you suing them, what are you suing them for, and we'll try at the end to put that all together in a way that you can email or communicate that to the people that you're complaining to and hopefully get their attention. Firstly, who to sue or to complain to. If, for example, you've purchased a car by way of a finance agreement, albeit through a car dealership, then any complaint that you have about the quality of the car or the description of the car or things that were said or done by the car dealer during the transaction to buy the vehicle will be made or should be made directly to the finance company. If, on the other hand, you've bought a car from a dealership and they're operating under a trading name, you're going to want to know who is behind that trading name. Is it a limited company, for example? Now, all companies should publish their company reference number on their website, and it also should be included in their sales invoice and any other correspondence that you have with them. You can take that number, put it into the online Companies House website, and that will reveal the limited company that's behind that business. On the other hand, if they've got a VAT number mentioned on their invoice, you can go on the HMRC website, put that number in, and again, it will tell you to whom that VAT number is registered. If, on the other hand, you're buying from a firm that only has a trading name, they don't have a company reference number, they don't have a VAT number, but you bought the car in response to an Auto Trader advertisement, you can email Auto Trader at customersecurity@autotrader.co.uk and explain to them what's happened, what you've bought, from whom you've bought it, and ask them to provide to you the identity of the person that put that advert in. Secondly, why are you complaining or suing? It's not enough just to say that you're complaining because the car's not fit for purpose or of satisfactory quality. You have to actually identify what it is you're complaining about. It's not enough to say that there are warning lights on the dashboard or that you've taken it to a garage and they've downloaded some fault codes from the car and that somehow proves that the vehicle is faulty. That won't do. The rules require you to provide documentary evidence of precisely what it is you're complaining of. For example, if hypothetically you had a problem with your car's gearbox, you'd have to take it to a transmission expert or a suitably qualified mechanic. You'd want them to note down in a document or an estimate what they did, when they did it, what they found, what's wrong with it, and what it's going to cost for them to replace it. In short, you have to have evidence which supports what you're complaining of. If you're complaining that the vehicle was sold to you with full service history, you're going to need a copy of the advert that says it's got full service history, and you're going to want information that proves that it doesn't have full service history. Third, what are you suing them for? It is true that the vast majority of complaints that come to a place like this and to the Financial Ombudsman Service are about quality. That's to say, Section 9, subsection 3 of the Consumer Rights Act deals with satisfactory quality. However, satisfactory quality is a generic term. We want to identify precisely what we're complaining for. So, for example, in the case of our gearbox that failed after 3 months, and we've now got evidence to prove that it's failed prematurely, there's evidence that it hadn't been previously serviced and that it requires replacement, we can complain that the gearbox failed prematurely and that it did not endure or it did not last for a reasonable period of time, contrary to Consumer Rights Act 2015. On the other hand, if we're suggesting the car is somehow unroadworthy, we'd want to be putting the car through an MOT, proving that it's unroadworthy, and then we'll be complaining that the vehicle is not safe, contrary to Section 75 of the Road Traffic Act, for example. If we're complaining that the vehicle doesn't have full service history, or that the mileage is incorrect, or it's had more owners than one has suggested it did have, then we'll be complaining that the vehicle does not match its description, or that somehow you've been misled, or the vehicle has been misrepresented to you. And finally, we've got to be able to put all of that information together in a way that the car dealer or the finance company understands that. And I do not suggest that you use the standard template letters that you get from the Citizens Advice. I think they're just too generic. So I'm going to give you an example. You're going to have to fill in some of the gaps, but here we go. Dear Sir, RE, Ford Fiesta, registration number XYZ123. As you know, I bought the vehicle from you on the 1st of February 2024 for the sum of £10,000. You will also know, and evidenced by the attached documentation, that 3 months later, on March the 5th, 2024, the vehicle gearbox failed and it requires replacement at a cost of £5,000. This information amounts to a breach of contract under the Consumer Rights Act 2015, and you are required to repair the vehicle for me free of charge without causing me significant inconvenience, and do so within a reasonable time. Or if this vehicle has a serious issue that goes to the very heart of this transaction, which may be the case if the engine has somehow failed, for example, or there's been a previous repair, then you'll be asking them for a refund. That will be either to unwind the contract in the case of a finance agreement, or to accept the rejection of the vehicle and to refund you the purchase price. I hope this video has been useful. If you have any further questions, you can contact stormcatcher.co.uk or telephone us on 0333 7676.